So welcome to the final webinar of Contemporary Challenges in American and Global Law. I'm Leah Wortham, Professor Emerita of Law at the Columbus School of Law of the Catholic University America. I'm the Catholic University Director of the American Law Program and LLM program, in which Catholic University has cooperated with Jagiellonian University for many years. I will be your moderator. Cristina D'Amelia Lopez, Director of Advancement for the Law School, its Development and Alumni Relations Office, will now bring greetings from the Columbus School of Law of the Catholic University of America.
Thank you, Professor Wortham. Hello, everyone. Again, Professor Wortham, thanks so much. Sincere congratulations on the execution, commitment, and creativity in curating these 16 outstanding virtual programs. Today's the final program in the series, as Professor Wortham mentioned. The series of web programs are archived and have been widely viewed through links on the law school website. The series has been such a success, connecting our international community of alumni around the current legal issues. And we're wrapping it up today, unfortunately, but there'll be more to come. The partnership between Jagiellonian University, the best law school in Poland, has flourished under Professor Wortham's leadership. The 30-year relationship's deep roots have been invigorated by this web series over the past year. Catholic Law and the Jagiellonian University's model partnership was founded by Emeritus Professor Dechert. Welcome all. I think we have over 130 participants registered today, alumni of the International Business and Trade Summer Law Program, the American Law Program, and the LLM in American Law. We now have more than 2,000 US, Polish, and other international alumni. As with each program, our panels today are superb. Today, we're really looking forward to hearing from Wictor Furman and James Catano. Thanks again, and welcome to the program.
Thank you. Wojciech Bancik, of the coordinator of the American Law School, will now bring greetings on behalf of Jagiellonian University.
Very much, Professor Wortham. Dear participants of the series of webinars, it's a great pleasure for me to express on behalf of the Jagiellonian University the undeniable happiness that you all joined us during this last online meeting in the series of Contemporary Challenges in American and Global Law. But hopefully, this is not the last time we meet. We are very glad to observe, again, such a huge audience who shares our passion. The fact that we are all here, despite beginning a long weekend in Poland, allows to hope for many common activities. Thus, we look forward to developing cooperation of the Jagiellonian University with the Catholic University of America continue, and new programs, as we do hope, will soon revive after the pandemic. This is already happening. We have launched recruitment for the next year's American Law program, and we look forward to this program to be a live one, a characteristic we so much look forward after the series of online meetings. At the same time, we are very proud that the transatlantic cooperation strives in this form, even during the pandemic, despite technical problems and without the possibility. This position allows me to present the gratitude of the persons without whom it will never be possible for this event. To reassume, we are very excited with this new way to learn and to meet together. At the same time, we do hope that sooner, hopefully much sooner than later, we will all meet in person at our programs or alumni events.
This webinar series is a team effort, starting with the support of Dean Stephen Payne of Catholic University and Dean Jerzy Piesiński, Dean of the Faculty of Law and Administration of Jagiellonian University. It draws on the leadership and staff of the Jagiellonian Center for Foreign Law School Cooperation, often known by its Polish acronym OXPO, and the Catholic University and Law School Development and Alumni Relations and Communications Offices, as well as help of our LLM coordinators and LLM graduates, Gaspar Cote and Luke Bartosik. We are pleased that so many of you have joined us for several webinars over the 16 webinar series. If you missed some you would like to see, they are on CUA's YouTube channel, and there are links to recordings that can be reached from the series website. As of May 31st, there were almost 1,500 YouTube views from those series, and they continue to grow. We are cautiously optimistic about returning to the live ALP on our normal schedule in the fall. In the chat, you can find links for an ALP information session on June 17th at 7 p.m. Polish time. Online entrance exams for the ALP are scheduled on June 9th at 3 p.m. and Thursday, July 1st at 6 p.m. The entrance exam is waived for people who have attended 12 of these webinars, and we're happy to see how many people that has been. We've also scheduled an LLM information session for Wednesday, June 30th at 6 p.m. Polish time. So now today we turn to today's program by Wictor Furman, followed by comments by James Catano. I expect most of you used Zoom before or a similar video conferencing platform, so you know about typing questions in the chat. I'll be taking questions from the chat and posing them to the speakers. You can type your question directly in the chat. If you prefer, you can click on the drop down where it says everyone and go to my name or Luke Bartosik's name and send your question privately. You can also send a private chat to anyone you see on the webinar if you see an old friend or classmate with whom you would like to connect. So in addition to the chat button, you will see the participants button where you can see those names. Mr. Furman will speak for about 20 minutes. He'll be followed by a comment from Mr. Catano, who will also lead off the question and answer period. After Mr. Furman answers Mr. Catano's questions, I will pose questions from the chat to either or both of our speakers. The session is being recorded and the 60-minute webinar will be posted. The series website links to the recordings. At the end of 60 minutes, I'll close the formal webinar and we'll stop recording. But Mr. Furman and Mr. Catano have agreed to stay on for up to half an hour so we can answer more of your questions. I'll now give some brief introductions. Wictor Furman is a Stockholm-based lawyer specializing primarily in banking and finance, as well as real estate. He has his own firm now, having worked previously in the Magnuson and Harvest law firms in Stockholm, as well as 2 major Scandinavian banks. His practice includes regulatory and legal matters, dispute resolution, and transactions for clients, including fund companies, securities firms, credit institutions, insurance mediators, and real estate investors. He's co-authored articles on financial regulation in the Swedish law journal, New Juridic. Mr. Furman completed his law degree at the Stockholm University in 2008, received his LL.M. from CUA in 2009, and was admitted to the Swedish bar in 2015. James V. Catano is a partner in the financial services practice of the Washington, D.C. office of the Dechert firm. Dechert has more than 900 lawyers in 26 worldwide locations. Mr. Catano has extensive experience counseling mutual fund complexes, investment advisors, and insurance companies on a wide range of securities, regulatory, corporate disclosure, transactional, and other financial services matters. These matters include complex fund reorganization transactions, preparation of registration and proxy statements, ongoing compliance and regulatory matters, and securing exemptive, interpretive, and no action relief from the U.S. Securities Exchange Commission or its staff. Mr. Catano also advises clients on development, regulation, sale, and administration of a variety of investment products, including open-end and closed-end mutual funds, money market funds, exchange-traded funds, and variable and fixed life insurance and annuity products. In addition, he advises boards of directors, trustees of U.S. registered investment companies on fund governance and fiduciary matters. Prior to joining Dechert, Mr. Catano worked at another international law firm as a law clerk at the U.S. Securities Exchange Commission, at the U.S. Commodities Futures Trading Commission, and as a legal and regulatory policy fellow of the U.S. Chamber of Commerce. He holds a JD and MA degrees from Catholic University, as well as a BA degree from the University of Virginia. So we will now turn to Wictor.
Thank you, Leah, and hello, everyone. So, and thank you for the introduction, Leah. Yes, so I've been working within the financial industry for in excess of 10 years, and when I got the question from CUA to have this webinar, the fund industry was a given choice for me to talk about, as this is an area I spent a lot of time in. And preparing a webinar, a good thing to talk about are the trends, and to talk about what's happened in the industry. And when I actually started to plan the presentation, I realized, wow, it's happened a lot in the financial industry and the fund market. So it has been a challenge to find good topics for the 20-minute webinar. But I'm going to change the slide. There, yeah. So I've chosen the topics which I find, or some of the biggest topics which I find have affected the fund market the most in a couple of years, and the regulatory changes are constantly ongoing, occurring. And new rules are coming all the time, but here we focus on the biggest topics, and I will also have the focus on EU directives and regulations, meaning, so what I'm saying usually would be applicable for all member countries within the EU that have similar rules. I mean, as you know, directives need to be implemented in each member countries in local laws and regulation, but EU regulations are directly applicable for the member countries. And my focus will also be to not go so much deep into the regulatory details, but rather talk about the effects that the rules have had on the financial industry. But before I go into the different topics I want to talk about, I want to start with some basics about fund management or investment funds.
No.
I guess some of you might be working within the financial area and are well familiar with fund structures. However, to get everyone else on the same track and having an understanding of how the fund markets work, what is a typical fund structure, and particularly the role of a distributor, we'll start with this slide. So funds, generally in Europe, we have two kinds of funds or fund regulations. We have the UCITS Directive regulating UCITS funds, which is UCITS standing for excuse me, was someone saying something? No, thought that was someone trying to communicate. Undertakings for collective investments in transferable securities, that's UCITS, and what the UCITS Directive have implemented in EU is a standard for investments fund investing in transferable securities. Following the UCITS Directive came the Alternative Investment Fund Management Directive, which regulated everything else that was not the UCITS fund. So this is the basic fund regulations in EU. So, and the fund, usually the fund is a legal entity. However, there could be some other forms of the fund. For example, Sweden have way of structuring funds in a contractual way where the fund is practically a pool of assets rather than a legal entity. The fund have, of course, the investors, the unit holders, putting money into the fund, receiving units in respect of their shares in the fund. What is also important here to know is direct investments are found relatively, I would say, uncommon. Most of the investments in funds are done through different kinds of distributors. Here we're talking about banks, securities firms, and other financial institutions routing the investors into the fund. So when a regulatory change is coming which affect the distributor, actually it also indirectly affects the fund industry, as distributors might be limited or in other way regulated by the change. So it's and you will understand this when I'm commenting the different changes I want to cover in this webinar, that it is not always the rules directly applicable for the fund market that have the biggest effects. Usually there is a trustee depository, or usually there is a trustee depository in a fund structure holding the assets on behalf of the investors. And the fund manager's role is practically to take investment decisions, which are then executed by the trustee. The fund manager is also obliged to act in the best interest of the unit holders. So that's some basics about fund structures. Staying on topic on distributors, 2018, beginning of January, the MiFID II directive was implemented, affecting securities operations. So here we are, regulations that affected the distributors of fund. MiFID II directive was a very, very detailed, big regulatory framework for securities operations, meaning covering investment advisors, portfolio managers, custody institutions, so these rules have a significant effect on the distribution of funds. And going a bit backwards, before the MiFID II directive, inducements has been a quite significant part of the distribution structure of fund industry. Inducement is the formal way of describing it. One also talk about kickbacks. So it's all about this different kind of payments or way of remuneration to a distributor for the distribution of a fund. And previously, it was very common that the distributors to distribute a fund would receive a kickback from the fund manager, meaning that the fund manager would take the management fee from the fund, for example, let's say 1.5%, and sharing 0.6% to a distributor, for example, of course, depending on the agreement. But of course, if you have, or this creates a couple of problems, which I will go into in the next slide. With the MiFID II directive, a ban on inducement was implemented, or not a total ban, which the industry was extremely afraid of. The ban that was implemented in the MiFID II directive have effect, or is for portfolio managers, meaning that when an institution is managing the assets of a client based on a power of attorney, meaning that it could make changes in the portfolio without the explicit consent of the customer, you cannot receive and keep inducements. And the same is the situation for independent investment advisors. So when an investment advisor is claiming that it is independent, this is a choice an investment advisor can, or the firm needs to do. So when we're talking about independent investment advisors, these could not also receive and keep inducements for their services. And for all other kind of investment services provided under the MiFID II directive, you can still receive and keep inducements, but only if they are designed to enhance the quality of the relevant service to the client, meaning that for keeping the inducement, the investment firm must show that the client gets some kind of positive effect of that. It could be, for example, that the client is given access to a fund platform with selected funds which are analyzed and evaluated. And then the second requirement is, of course, that the inducement cannot impair compliance with the firm's duty to act honestly, fairly, professionally, meaning that it cannot create any particular conflicts of interest, for example. UK and Netherlands went further and introduced a total ban on inducements, meaning that generally what that means is that clients to receive these kinds of investment services, we're talking about investment advice, portfolio manager, we're talking about other investment services like analyze, we're talking about custody accounts, needs to pay. This is not something that could be financed by a third party by kickbacks. So And even though we are here looking at rules which came 2010, this is still a very hot topic. Swedish Financial Supervisory Authority went out in February this year with a new announcement that they were pro to implement a total ban on inducements in Sweden. ESMA last year went out with the opposite communication that they did not recommend a total ban on inducements within the EU. So it's still a very hot topic, and the MiFID II package was so big that it's still quite a lot work going on to be fully compliant with the MiFID II directive in the financial industry. To understand inducements and the ban on inducements, what kind of effects it creates for the financial industry and the fund market. The pros, of course, and what has been the motivation to implement this ban is consumer protection, particularly the retail investors that earlier maybe was not that aware of how much kickbacks were actually received by their portfolio manager or investment advisor. So it's removing the conflict of interest between the client and its service provider. But there are, of course, problems, as with everything. There are two sides. So the negative side, the downside of having a ban on inducement is that certain clients are locked out or could be locked out from financial services like investment advisors and portfolio managers. You're talking about retail clients which do not have such big assets to invest and maybe don't have money to pay for these services. Also, what a ban on inducement means, it increases closed architecture models and creates vertical integration. What does it mean? It means that, let's say, a typical bank, which is not one entity but a group of entities. A bank have usually its own fund company, its own investment management company, investment advisory services, and so on. So for the banks, and usually the banks normally try to sell by its own advisors and portfolio manager the own funds of the bank. So limiting the possibility to pay for distribution is not a problem for the bank, as after all the revenue staying within the group. But of course, it limits the possibility for other companies to enter into strategic partnership with distributors, and which affects smaller fund companies, making it hard for them to stay on the market. So this is something I think that ESMA has been very keen about and we have seen a quite significant consolidation on the fund market, where smaller funds have been more merged into bigger ones due to that they had a hard time to attract the amount of asset under management required to run the fund. So this one has been very big, or have had very big effects on the market. Going on to the next topic, now the MiFID II, big part of the MiFID II. MiFID II generally contains a lot of disclosure rules for these kinds of securities firms, or firms working with securities operations. And one particularly interesting part is the transparency of costs and charges. And of course, funds do have own rules for disclosing information about management fees. We have the KID document, key investor information document, which contains a table on the percentages for management fees. And there was a requirement to send an annual statement to each investor showing exactly how much that investor had paid. But this is just numbers. MiFID II went a lot further, and for these distributors implemented very, very detailed, very hard rules on transparency and cost and charges, which of course means that the funds that the distributor is distributing needs to consider these funds management fees when providing this mandatory information. So the information requirement covers both ex ante, ex post information. So both before the investment is done, information must be provided to the customer, and then also annually in advance. And what is presented in before the investment is done, that's of course a calculation based on the fund's fees and the intended investment of the investor. So here we're talking about very detailed information based the amount that the investor wants to invest, the exact fees, and not only for the funds, but it must summarize, the distributor must summarize with all other costs related to the fund investment. It could be, for example, if there's a custody account or life insurance where the fund units are going to be held in. These costs need to be included. Also, transaction costs, for example. So, and the most, I think, interesting part here is the requirement on illustration. So not all these costs must be very visually presented to the investor. With illustration, ESMA has clarified. ESMA is the European Securities Market Authority. It's clarified in its guidelines that illustration mustn't be explicit, for example, a table or a chart. It could be a descriptive text with numbers, but Sweden, for example, has a market standard has been charts like this one on the left side you see here in the presentation, where the effect, this particular chart you're seeing on the left side on the slide shows an investment of 100,000 and with the expected performance of 7% per year. And the illustration must show both how it would look like if the outcome would be positive and then negative. And usually you calculate with the same if an expected return on 7%, the potential downside is also 7%. And you see here that the chart is both showing both what the development of that 100,000 would be without fees and then with deducted fees. So that's giving a very in your face, if I call it so, description of what kind of costs the investor are paying with an investment. And this, of course, pushes the costs or the possibility to take management fees quite a lot. We've seen also in the statistics from the ESMA that fund management fees are going down. It's not a quick change, and the statistic right now are from latest 2019, as there's a delay in the numbers because ESMAs are awaiting the annual reports from the funds, so there's a delay for about 2 years. But we've seen decreasing fees. So investors today are a lot more aware of what they're paying and they don't want to pay. The picture on the right side is just it's another example. It's a table, so it's not a chart, but it's a table with numbers. Actually, I took that one just quickly from the internet, but I realized that it's actually not compliant because it's not showing the downside, how the investment would look if the performance would be negative. So, yeah. This is it's harder to take high fees today, and you cannot get away with it as it was possible earlier. So let's go on to fund-specific regulatory change. We're talking about the Shareholder Rights Directive, came 2019, and this directive regards disclosure rules for asset managers. So it's not only fund managers, but fund managers are included in the definition of asset manager under the Shareholders' Rights Directive, and regards investments, the client's investments in shares traded on a regulatory market. So when asset manager, like a fund company, is managing a fund, investing in shares, shares, with the shares are also following voting rights. So, I mean, the fund manager have a responsibility to treat these voting rights in a proper way. And it's, of course, not the obligation to use the voting rights. It could, in some situations, be necessary, and we'll come to that. But what this directive has implemented is this disclosure requirement to first, I mean, all asset managers carried by this directive needs to inform or publicly disclose its engagement policy, saying how do the asset manager use voting rights. So a couple of points including that in these rules. Also, and this must be published on the asset manager's website. Also, there are disclosure rules in the annual report where the asset managers need to disclose what have they actually done the last years with the voting rights. So the consequence in first step for these covered entities is that they need to take a strategic decision. Do we want to use the voting rights or not? And if we want to do, how should we disclose it to the public? And there is talk also about ESG rules, but there's an ESG aspect also on this where maybe if you are, for example, a fund manager managing a green fund, you would maybe then be expected to use your voting rights to assure that the underlying investments in the fund that you're investing in are that the shareholders meeting are voting in a way that is compliant with the ESG policy of the fund. So that's another aspect to consider. And then we come to the, I think, biggest topic right now in the financial industry is the sustainable finance disclosure rules. There are two directives. I can also here say that there's been a webinar previously this year where Mr. Gaspar Cott has talked particularly about these two regulations. So I will not go into details, but rather talk about the effects on the fund market. But just to summarize, the taxonomy regulation defines what is a green financial instrument. So the goal here with the taxonomy regulation is to take away greenwashing, which previously before this regulation, of course, when the ESG trend, it's a big part of society now, but previously there wasn't expect or demand for green products, and with no regulatory framework around greenwashing was a very big risk where bond or fund was claimed to be ESG, to be an ESG product, but in fact maybe it wasn't so true after all. So taxonomy regulation is setting up what is a green financial product, and it's based on the UN's 2030 agenda for sustainable finance or sustainable development. So there are a couple of goals. We have 17 goals, which the United Nations want to be fulfilled 2030, and this is what the taxonomy is based. We're in the taxonomy directive. Regulation. It talks about practically three types of financial products. They're classified as dark green, light green, and not green or non-ESG. So this is the first part, and then we have the disclosure regulation, which particularly says what kind of information must the covered entities disclose, and these rules apply both for fund managers and the different type of financial institutions that are distributors to fund managers. And you need to disclose information about sustainability risk, principal adverse impact of certain investment, sustainability targets. Also, you need to, which I think is quite interesting, detailed requirement. You need also to disclose how your remuneration policy within the firm is compliant with your ESG policy, meaning if you have an ESG policy, have you assured that there are no conflicts of interest where, for example, an employee might be tempted to make an investment or take a decision that is not ESG compliant or in line with the ESG principles of the firm just to increase its own income. And fund managers are classified as financial market participants and funds as financial products pursuant to these rules. So particular rules applies on the entity level for the fund manager, and some rules applies for the product, meaning the fund. And to understand more, I mean, so you can, of course, as a fund manager, choose to take the decision that the fund shall not have an ESG focus at all within its investment strategy. But it's not, after all, so easy, because, as I said, the distribution side is very, very important for the fund market. And many distributors, one, of course, they have the same requirement to take decisions whether to offer ESG focus on their services and products. Like a portfolio manager need to consider if its portfolio are having a ESG focus. So the investment advisor need to consider the ESG preference of its customers, insurance companies offering life insurances or insurance-based investment products, as they're called by EU directives, the Insurance Distribution Directive language, needs also to disclose if the product have a ESG focus or not. So, and of course, pension trusts, a typical example of long-term investors, which always will have an ESG focus. So given that all the distributors have these requirements on themselves, and where the focus or ESG part is very, very important for the distributors, the fund managers are, I would say, not forced, that's the wrong word to describe it, but there's a big pressure on the fund market to offer green funds, to call it so. So, of course, the increase of generally, I would say, green products on the financial market has increased significantly, but also within the fund market, we've seen that a lot of funds have came with an ESG focus and have changed its investment strategy to include an ESG focus. And this is to both comply with the new rules, but also to make sure their old investors stay and that they can attract new investors with ESG focus. I see here that the time is flying. I will just shortly summarizing the situation in the financial industry. I mean, the regulatory burden, the amount of new rules and requirements on the not only fund manager but financial institutions have increased, which means increased cost for compliance administration. It's made the as I was talking about, it's harder to take high management fees for funds today, meaning that on one side you have a higher cost for a compliance administration. On the other side, it's harder to it's a pressure on the management fees, meaning that you need to have a higher asset under management to reach or break even in the firm, which of course had led to the consolidation in the industry, which I talked about. Wiping out some of the smaller market players. Generally, there are a lot of strategic decisions, to summarize what I've been talking about, that the fund managers need to take. What kind of distribution strategy should I have a ESG focus, and so on. So yes, it's challenging times for the fund managers. And just to look, I think it's maybe too much to say, but looking just what kind of other big topics is in the pipeline for the nearest future. I think on EU level we'll see more about disclosure on funds activity for actively managed funds. This is actually a topic that in Sweden is quite highly debated, and also we have right now these rules exist in Sweden, where a fund manager which claim to offer an actively managed fund need to disclose the activity, which is disclosed by usually by a measure called tracking error. You need to compare it to a similar index, and the closer you are to the index, the less active you are, to make it easy to understand. I also have seen a quite interesting court case from Norway. I think it was DNB, where the DNB lost a case where it was accused to not have had active management in a fund that was claimed to be should be actively managed. And the court exactly as with the disclosure rules in Sweden, the court looked on a similar index and realized that the fund actually has been more closely managed as an index tracker rather than an actively managed fund. So it's very close to the index it was following. And actually, what the court case ended in was that in a damage where the investors in the fund did receive money back, and what the fund court compared was how much would the index tracker fund cost and how much did that fund cost. And it was quite significant difference. I think that fund cost about 1.5%, while a similar index tracker would have cost 0.3%. So 1.2% was calculated as the fee that the investors were going to get back. Money laundering is another very big hot topic for a long time. I think we'll see more there. This is, I think, both politically driven with all the money laundering scandals in the banks, but also there is, of course, a lot of work still that could be done to make the measures against money laundering and terrorist financing more effective. For example, information sharing, public registers, and that. And sustainability, definitely a new hot topic that we will see more of. Yes, so this is what I wanted to talk about.
Thank you so much, Victor. In the mysteries of Zoom, we think that the echoing is being caused by Victor's mic. So Kate is going to mute you, Victor, when you're not talking. So to our audience, it might take us a second to get Victor muted and unmuted again, but that seems to be what was causing the echo when other people were talking. So I'm going to turn now to James. And Victor, you can unshare your slide now and tell your screen and take it off. So James.
Thank you, and thank you, Victor, for your commentary and those insights. Certainly important developments happening in Europe. They're impacting the asset management space, and we're seeing a lot of significant regulatory changes in the US as well. And one of the goals of this webinar is not only to provide commentary on some notable recent developments that are impacting the asset management space, but also to provide some comparisons and contrasts between these developments on both sides of the Atlantic. So I'll provide my perspective from the US side and briefly comment on some observations in each of the areas that Victor reviewed, and if we have time, perhaps a few others. But maybe as a general matter, just to level set, perhaps not surprisingly, there are similarities and differences as between US and European regulation and rules relating to the asset management space. But also at times we see regulatory developments operate in parallel. And certainly that's the case for each of the areas that Victor just discussed. So ESG, what I'll refer to as disclosure or transparency, and the distribution or sale of investment products like mutual funds. To walk through these individually, first I'll start with ESG. Similar to Europe, US asset managers have seen for the last few years and really recently an increased demand from investors for strategies that at different levels incorporate ESG. And certainly this is a trend that we're seeing also in the operating company level in the US, but just focusing on the asset management side, there's really in the US no single definition of ESG from a legal or retail perspective. So certainly seeing many variations on what is meant by ESG as interpreted by an individual asset manager. It's a very amorphous concept, to say the least, today in the US. So this has led to really a broad range of categories within the ESG space, ranging from what's been referred to as integration, essentially considering ESG factors, criteria, or risks in parallel to or alongside more traditional risks, credit risk, for example, to really exclusionary screens that have a form of objective criteria that look to specifically exclude certain issuers or certain assets from a portfolio. But unlike in the EU, For the most part in the US, these have been driven by the asset management industry itself as compared to regulations. So what does this mean for asset managers in terms of a trend? In response to investor demands, publicity around ESG, many asset managers, US and of course globally, are offering new strategies or products within the ESG space generally, or modifying existing strategies, or in some cases really just more clearly articulating how these factors are considered or relevant to a particular strategy. One important point from a regulatory standpoint is that unlike in Europe, as Wictor explained, where there are specific regulations on investments in the ESG space, in the US currently there's no regulation that's explicitly focused on any particular ESG themes. But we do have certainly our generally applicable rules, regulations, and laws. So for example, anti-fraud protections, fiduciary duties, and principles of full and fair disclosure and client consent, all of which are relevant to disclosing and running an ESG strategy. But in the US, without that specific regulation, we're still seeing really significant regulatory focus on investment products that offer an ESG component. For example, from the US Securities and Exchange Commission. Most recently, the SEC's Division of Enforcement announced a task force focused on ESG issues, and the Division of Examinations published a risk alert on ESG investing and observations that they've had from examinations of funds and advisors. So certainly a lot of focus from the SEC staff in those respects, and I think it's fair to say at the more senior levels and the commission itself on ESG in the asset management space. But even without a specific regulation, as I mentioned, the breadth of fiduciary duty obligations, anti-fraud protections, disclosure requirements, policies and procedure requirements alike in the US certainly provide regulators with meaningful tools to regulate the asset management community in this space. So from an asset management perspective, as I mentioned, we're seeing strategies developed. We're also seeing asset managers spend meaningful time and resources developing clear and accurate disclosures, developing policies and procedures, really focusing on making sure that their teams really know how portfolios are being run in the ESG space, and then properly disclosing those. So essentially, it's a do what you say what you do type approach of making sure that you're properly reflecting what you're doing and doing what you're stating in your disclosures. So certainly both a business and regulatory hot topic in the US, and for asset managers, global operations, really heightened risk in this space in terms of strategies that are run in parallel and both have disclosure documents and investment teams running the strategies to really carefully consider how those strategies are being run and marketed and disclosed across jurisdictions. Really quickly, just at a high level, commenting on some disclosure regulatory changes in the US, really at the proposal level at this point, the SEC proposed pretty broad regulatory changes to the disclosure framework for US mutual funds and exchange traded funds, with the primary goal being to, from the SEC's perspective, better serve the needs and preferences of retail investors. This came out of, in part, a broader investor experience initiative, as the SEC called it, to really understand what investors were looking for in terms of information, presentation, and the like, and has led to a proposal that would provide for more concise and layered disclosure, more graphical representations than narratives, with the idea to provide investors with information that the SEC believes best enables them to assess and monitor their investments. So what would this mean in practice? Just a few points on that. In the US, for mutual funds, for example, there's really two primary disclosure documents: a registration statement, which includes a prospectus that's provided in connection with the sale of the security and updated periodically, and shareholder reports, which are provided semi-annually and annually, that attempt to provide information that investors may find useful on fees, expenses, risks, performance, and the like. And the SEC in this proposal is really looking to streamline those disclosure documents. So for example, one expectation is that some of these documents on the shareholder report side will be 3 or 4 pages, really providing key information to shareholders. In addition, the SEC proposed changing the presentation of risks and fees in fund documents to really more standardize the disclosure. So shareholders it's easier for shareholders to compare strategies, risks, fees, and the like across investment products. That's, again, at the proposal stage, would be meaningful to implement for asset managers from a time and cost perspective. There are also a variety of risk considerations around certain aspects of the proposal, but that is something that's under consideration by the commission. And then last, Wictor commented on ban on inducements and MiFID. And in the US, there's been a similar trend from a regulatory perspective to clarify and enhance regulations around the sale of products to retail customers. In 2019, the SEC adopted regulation best interest along with a broader package of rulemaking with the idea to provide more clarity to investors regarding the particular roles played by, broadly speaking, a financial advisor, whether it's a broker-dealer, investment advisor, and the like, and conflicts that might be present, fees that would be charged, and the like. And this regulation essentially provides that a broker, when making a recommendation to a retail customer, has to meet certain obligations. For example, disclosure, care, addressing conflicts of interest, and certain compliance requirements that essentially provide that recommendation will be pursuant to the broker dealers acting in the best interest of the retail customer and putting that customer's interest first. So what have we seen from the asset management side? Again, that's primarily a regulation that's on the broker dealer or investment advisor community. We've seen broad changes in what are referred to as share classes, essentially different pricing structures within an individual portfolio, mutual fund portfolio, that have been developed to help certain intermediaries or broker dealers comply with their obligations, which, as I mentioned, relate to, for example, conflicts of interest. So important there be the pricing of a particular class, how intermediaries are compensated, what costs a shareholder bears. And we've also seen intermediaries, broker dealers, for example, that have removed certain products from their lineups to really limit the number of variations that need to be considered from a compliance and operational perspective. So parallels in some respects, certainly differences in others, but it's really fascinating to see that from a theme perspective, we are seeing similar regulatory developments or interest or hot topics across US and European products. So I'll pause there in terms of US views on some of the topics and maybe pose a few questions for Wictor in light of some of the points that I just made. But Wictor, in terms of just going back to ESG and sustainable investing, in some respects, the concept isn't necessarily novel, but the focus is, and there's a lot of attention on developing policies and procedures and disclosure and the like. What did you see, or what are you seeing in terms of asset managers complying with the regulations or developing products or adjusting products to meet the new requirements?
Thanks, James. Kate is going to unmute Wictor, and we might mute him. For the recorded portion, we're going to maybe go a little bit because I'm going to let Wictor finish responding to James's questions before we end the recording, and that's when we'll end the recording. So Wictor.
Thank you. Yes, and the trend in the market is, of course, very pro ESG products, meaning that a lot of market participants has chosen to go into the field of green products, and with that taking on the burden of complying with all the regulatory requirements that follows with offering green products. And just to summarize how the these regulations works is practically that the more green you are, the more you need to disclose and inform. So it's easier to be non-ESG or offer non-ESG products, but on the other hand, the problem with that is that you probably won't get a lot of investors that are looking for ESG products. So a lot of companies has chosen to go into the ESG field and offering funds that are green or include ESG principles in the portfolio management strategies and so on. So I would say that more of the market participants are going into the ESG field that are choosing to stay outside, because this is such a big pressure from the market, such a big expectation.
So Kate, if you would mute Victor again. So James, if you had another question or two, that's great, and we're going to, or not, and then we're going to continue recording till we're finished with James's questions. In the meantime, those of you in the audience, please be thinking about your questions, because we will just continue on once we've Victor's finished with James's questions, and we will be staying on until 2:30, 8:30 Polish time. So James.
Thank you. So one other question, Victor. We both discussed points around transparency or disclosure. And as I mentioned in the US, and this one area of disclosure, potential reform, again, at the proposal stage, part of the goal there is to make information easier key information easier for investors to access, and really meet what is a perceived need from the SEC as to retail investors and their preferences and information that they deem material. From a rationale perspective, sort of the regulatory why, is that similarly what's driving some of the regulations in Europe, or maybe it's completely different? Welcome your thoughts.
Actually, I would say I totally agree with the principle that you're talking about here, meaning that there is a very good thought behind all the regulatory requirements that are coming, but when you summarize it all and I mean, of course, how the rules are designed is that for retail investors, we're not talking about institutional investors, the big ones that know what they're doing, but the ordinary people, to say so, the retail investors. For them, the full package of the disclosure rules applies, meaning that looking today how it is to open a custody account to receive some investment advice and investing in a fund, actually the amount of information that the distributor, so we're talking the bank or the securities firm, need to present to the client that's a huge amount of information. I mean, it's hard to say how many pages, but we're talking about the 30, 40, 50 pages of information. And then looking at it, even though the company is complying with information required, is it in fact helping the retail investor, or is it just making the investor overwhelmed with all the information and actually more confused than maybe helped? Unfortunately, right now we have not seen yet so much maybe from the regulatory side, from the regulator side, changes that are intended to help or decrease the information to help the investors, but rather than the amount is still rather big, and as it looks like now, it's staying that extensive.
Much. We're almost exactly at 2 o'clock, so we will in a moment end the recording. Luke, if you want to, we'll put one more time in the chat the links for the upcoming information sessions for the American Law Program and the LLM program, as well as the ALP entrance exam, for those of you who are interested and might want to pass on to friends. And so we now will move seamlessly on. Thank you for any of you who have to leave us. Thank you so much for joining us. And particularly since this is the final webinar in the series, I looked through the names of the participants and I see a lot of names of people who've been with us many times. And we particularly appreciate those of you who've continued to come back, and we're glad to see you. So moving on to the unrecorded part,